to the Senator, the Honourable George Brandis, QC, Attorney General and Leader of the Government in the Senate. Since Senate School, it has come to my attention that there is a discrepancy between Section 33 of the High Court Act 1979, which says that all process shall, which must, be issued in the name of the Queen, and the High Court rules of 2004. If this appears to be the case, why has the High Court felt free to defy the Parliament for 12 years?
Well, may we say, God save the Queen. Because nothing will save
the Australian Government. In this presentation, we're going to explore the events surrounding the Queen in the time of the Whitlam Government. There was, for reason that will unfold here, as we will have seen, presented to the Federal Police in an ongoing investigation, assisted by the Australian Electoral Commission, that goes to our previous former Prime Minister, former Attorney General, former President of the Senate, prior party leader, and, of note, prior family member squatting on vacant office, that the Whitlam government set about to remove itself and future governments from legal authority. And that's my open. It will be seen through the images here that a design was underway to alter the way in which the government does business. In 1972, there began, in earnest, an invention of an office of the Queen by the Whitlam government for a particular purpose, and that was to defeat the Commonwealth, or, it may be said, the Australian people. The Commonwealth is our collective authority that every government in Australia runs under. It's the authority that the courts run under. It's the authority that the Queen serves and rules by. It will be shown here that the scheme to defeat our authority was made by removing our Queen and our Commonwealth. The manoeuvres set about by the Whitlam government to compromise the monarch in a Crown capacity and office was done by way of adopting a non-Crown title, and had to be done as seemingly agreed to and as seemingly created by an Australian federal law, but in fact by review of the evidence obtained and, as I'm about to show, was not. Before we begin, there is a need to be mindful for the intent and purpose why this came about and how the pieces to usurp the powers of the Commonwealth were put in place. It is a difficult thing to grasp why the Whitlam government, seemingly representative of the people of the working class, would undermine that very same class for their authority and rights that are inexpressive throughout the Commonwealth. Can it be that the socialist agenda was at odds with the inherent right and rights of people that underpins the Crown?
If I may say so, Senator Cullerton, it is very, very unusual, if not unprecedented, for a senator's question to find its way onto the agenda of the Rules Committee of the High Court of Australia. And I'm sure it is utterly unprecedented for a senator's inaugural question to do so. Thank you, Senator Cullerton.
To understand the events leading to the current state of affairs, we ought to apply the law principle, you shall be known by your acts and actions. It would be proper to begin with what had been orchestrated to remove the checks and balances in our law that would lead to path of removing the protection and understand why the courts have failed us in applying the proper standard of law. Primarily, what we see is that in the time of the Whitlam government, there were measures taken for later attempts to replace the common law of England from having the guiding effect in Australia and supersede its application with a common law set by the Australian judges in Australian courts, departed from the fought for protection that is our British heritage, a pedigree of law worth our claim. To this end of removing our historical protections, a provision of law that controlled the administration of justice had to be amended, and that was done in 1973 by a change of the words in the provision of the Judiciary Act of 1903, Common Law to Govern, which is a section found in section 80, and the change occurred to Common Law of England to read the Common Law in Australia. No longer were the courts held to the standard of the historical treaties and restraints against tyranny, and the Australian courts may allow the modern laws passed in Parliament to be accepted without proper regard to the English standard, which is the birthright of each of Her Majesty's subjects. There are two notable issues to consider here, both of these fatal to the change in the removal of English law in our courts. The first of these is that the change in the provision of section 80 for removal of the English common law was made in 1988, as stated to have been assented to on the 14th of December 1988, which came after the Constitutional Commission reports of that year. Reports that acknowledged the invalidity of the Queen of Australia. So one question that begs an answer is, how may the Judiciary Act of 1903 be amended to replace the words the common law of England with the common law in Australia by assent to the Law and Justice Legislation Amendment Act of 1988 under the assent of Queen of Australia having been found unconstitutional and invalid by the Commission appointed by the government of the day. The second, and perhaps the more notable issue, is the shenanigans entered into attempting to persuade the Queen in making change to the style and titles to the Queen of 1953. This change originally stated for purposes of the Commonwealth of Nations meetings set about in 1953 by the Royal Styles and Titles Act was never meant for domestic use, as it could never be, given that the office of the Sovereign Queen had already been identified and commanded for application within the Commonwealth in 1900 by the second clause of the Act, a paramount law that established Australia. Prime Minister Menzies stated in Parliament that we are not to divide up the Queen artificially, and this was for two reasons. The first being the second clause already identified the Queen appertaining to the Crown for exclusive use of constitutional powers within the Commonwealth. There could be, as of right or of change, no other. The second, although of lesser importance, is that because the second clause exists, there could be no grant of power to the Federal Parliament in which to make laws to do with the monarch. The monarch is above the parliamentary completely and out of reach of the authority of the Federal Parliament. This fact was identified and admitted to in those two constitutional reports in 1988. With the attempted enactment of the styles and titles for the Queen in 1953, it became understood by reading the 1988 reports that the Parliament could never have the ability to make such titles for the Queen and remove the Crown. A condensed version of Section 59 simply reads, "The Queen may disallow any law within 1 year from the Governor-General's assent, and such disallowance shall annul the law from the day when the disallowance is so made known. Here is the power and the duty of the Crown Ministers to protect us against bad law, against any violation of our fundamental right, and guard our heritage and that of future generations, as did our ancestors which fought for and guarded our rights." How did this removal of the Commonwealth come about? The Whitlam government sought in 1973 to make a purely Australian monarch that acted as divorced from the Crown, and only at the advice of the Australian ministers.
The Governor-General takes the advice from his Prime Minister and from no one else.
And must act on that advice?
Unquestionably, the Governor-General must act on the advice of his Prime Minister.
There is no tolerance here. He must
None whatever.
Here are the entering of the secret letters of 1973 between the Whitlam government and the representatives of the Queen. In late 1972, it may be revealed that the Whitlam government set about events to negotiate, in secret and hidden from the public view, changes to identify of all Australians, our name of the Commonwealth, our allegiance and the status of the Queen and her representatives, the Governor-General. Only the change to our national anthem was the part of this change that was not concealed. The secrecy in which this was conducted is now to be understood against the backdrop of the Commonwealth and its 73-year history of federation under a crown and its enforceable set of terms and conditions. It seems that the Commonwealth, a right of every Australian, was to be dictated by a change, by wholesale removal of authority in which it came to be. This change would otherwise have needed consultation with the Australian electorate, and yet it was done in concealment. I wish to bring you the evidence and agenda in which this was done by presentation of this once secret file in the next of the series in discovering the theft of our Commonwealth and substitution with a counterfeit.
Now, Senator Cullen, it was you who spotted this discrepancy. It was you who spotted the discrepancy in the High Court rules, which the High Court Rules Committee has now acted upon. I might say, since those rules were promulgated in 2004, there have been 16 distinguished Australian jurists sit on the High Court, including 2 Chief Justices. And I must congratulate you, Senator Cullen, on being the first person to spot the problem.